We got one question from Jim Rakowski, who's talking about fees. He says that he thinks California might be unique in that attorneys are rewarded a fees based on the amount of the estate. Does that then create for the attorney an incentive to maximize the value of the estate, or is that and does that work to the estate's benefit or just the attorney's benefit?
But we have a duty to maximize what comes into the estate. So our duty is to the administrator, whose duty it is to maximize what comes into the estate. I'm not sure if that is anymore. So even if you awarded me a flat fee, for example, I still would have the same duty as maximize what into the estate. And that's so that it benefits the estate. But sometimes that doesn't happen. And the reason for that is if there is some dispute about ownership of the property, you may think you have $1 million estate, but at the end of the game, you may end up with a $500,000 estate if the estate actually is not the owner of that or ends up not being the owner somehow in settlement, etc. So, luck the draw.
You know, the way you say, and I know because I know you, when you say the word duty, you take it so seriously as an attorney. And I think in general, attorneys take that very seriously. I'm a realtor. I have the same duty you have. I have the same moral, ethical responsibility you have. I also, in some regards, have the same legal obligation, but I rarely hear a realtor say it with the intensity and the meaning that you just said. Speak to me a little bit about attorneys. It just seems, now my father's an attorney. I've been around attorneys my whole life. But it seems to me they take that more seriously than other professions. Is that just my experience, or is that why I want to pick up from that?
I'm not sure. I've had interactions with realtors, with brokers, and we all have rules of ethics. We all have to live by. And I think most of the people I've met have dedicated themselves to that profession, so they understand the actual duties of care. So it's more than a duty of care, it's a duty of loyalty that we owe. If you're a realtor in California, you're a fiduciary to your client. So
Right.
that is an issue. I mean, I know you guys can do dual representation, and I know I've seen in forms that, you have to disclose the confidential information to both sides if you do dual representation. I always find that interesting.
Yes.
Because I say to myself, well, if I'm the seller and if I tell you, Bill, there's, I'm not going to take any less than $500,000, and you know that I have to pay my creditor, for example, $100,000 in 30 days, even though I'm saying to you I won't take less than $500,000,
Right.
then I might in fact be taking less.
Right.
So where does that put a realtor who dually represents a buyer and seller? What would you be able to tell the buyer?
I agree with you. 99% of the time, I agree with you. I find it so uncomfortable. Generally, you sign the listing agreement first. So you now have a client to sell the house. The other person who calls you isn't yet your client. How can you possibly serve them in any way that lowers to your client that you have a contract with? And my answer to that always is, if my seller would want me to help that buyer, if there's some reason why I can uniquely make it happen, then great. But that's a very rare circumstance. Maybe it's a real small property where other agents won't waste their time on it, or some other reason. But I agree. I don't understand how agents so regularly, and that's why I got involved in probate, to be honest. I saw so many double ending. So how can it be, of all of LA County, that person seems to double end their listings half or 2/3 of the time? It's impossible. There must be something else going on here that's not serving the client. And that became my opportunity. So.